Okay, I think we're going to go ahead and get started. Good afternoon, everyone, and welcome to today's webinar. Again, I'm Michelle Peterson, and I'm the Training Manager for the Empire Justice Center. First, I do need to note that today's webinar is made possible by the New York State Attorney General Homeownership Protection Program. So before we get started, a quick note on how you can interact with us. Everyone has entered the webinar in a listen-only mode, so if you have any questions on the materials being presented during the webinar, you can enter your question using the questions pane located on your control panel. We'll be addressing questions both during and at the end of the presentation. The materials for the webinar can be downloaded by going to the handouts pane on your control panel. Here you'll find the PowerPoint presentation and the attorney affirmation form. Today we're going to be providing 1.5 CLE credits in the professional practice category. So to receive your certificate, you'll need to note the verification code on your attorney affirmation form when we announce it and send your completed form to my attention. And to do that, you can either email it to me, a scanned version, or you can put it in the regular mail. Either way is fine. For anyone looking for a certificate of attendance, we can also provide that. So to request that, you can send me an email directly requesting your certificate, and I'll get that out to you. And finally, at the end of the webinar, you're going to be asked to complete a webinar evaluation. So take a moment and complete it for us. We appreciate your feedback. With that housekeeping out of the way, I'm going to turn it over to Becky Kygo.
Thank you, Michelle. So as you can see, today we have a back to basics type of webinar. This really is for those of us who have not been in law school for quite some time, and for those housing counselors who are on the line, welcome to a brief version of law school. So we are just trying to do a repeat, actually. Jeremy did this presentation for the folks in New York City back at the end of February, I believe, and thankfully he was gracious enough to offer it and repeat it to those of us in the rest of the state. So this really is going to be led and primarily moderated by Jeremy Sheff, primarily because we have a professional on our hands. As you can see, we have a lovely video. We have somebody who does this on a regular basis, so he is more than capable of managing this mostly by himself, so you will hear me very little. So with that, Jeremy Sheff, and he's with St. John's University School of Law, and he's agreed to just do a refresher for us. So thank you very much.
All right, thank you, and thanks everybody for coming. This is, excuse me, a refresher course on very basic principles of real property law for those of you who are in foreclosure prevention advocacy practice. So to give you an overview of what we're going to be talking about today, we're going to be talking about New York's system of estates and land, including estates divided according to time and estates divided according to the number of people who hold an interest in the same real property. That's the subject of the section on concurrent ownership, which we'll be getting to after the introduction to the estates and land. We'll then look at how title to real property gets transferred via deed or in other forms of transfer. And we'll look at some of the issues that can arise with respect to those transfers, including the forms of transfers provided by statute in New York State, as well as issues of forgery and fraud, which may be particularly relevant to your practice. And we'll look at what the law is regarding those kinds of issues. And finally, we're going to look at the recording system, which provides some protections and also some ways around certain transfers where certain requirements are met, and we'll be talking about those as well. Throughout the presentation today, I'll be pausing at various points at the end of each section to answer any questions that pop up. If I'm looking over to this side of my screen, it's because I have your questions window over here on a separate screen that I can monitor while giving the presentation, and I encourage you to write in any questions you have as they occur to you, and I will at appropriate points in the presentation stop and do my best to answer those questions. So without any further ado, let's dive into the topic. So the system of in land, in real property in New York, is governed by statute, Section 6.1.1 of the New York Estates Powers and Trust Law. The various forms of estates in real property are classified in two ways, one according to duration and the other according to the number of people who hold an interest in the same real property. 6.1.1 deals with duration. So estates in property as to duration are classified in the 8 different types of classifications that you see here. We are going to be dealing with the first 4. The estates 5 through 8 are leasehold estates, which are generally not of particular interest in foreclosure practice. So if we focus just on these first four, you see we have the fee simple absolute, the fee on condition, the fee on limitation, and the estate for life, or the life estate. And we'll go through each one of those to try and understand what they are and how they differ from one another. So beginning with the fee simple absolute, this is the one you probably don't have any trouble remembering. The fee simple, or the fee simple absolute, is the greatest interest that can be granted in real estate. It includes title, the right of possession, and the right to use for any purpose which may be lawful. When we say that I own this land, what we really mean is I own a fee simple absolute in this land. This is a classic lawyer's trick of separating the thing from rights in the thing. When we talk about a fee simple absolute, we are talking about the greatest rights in real property that the law will recognize. So far, so good. We move then to the fee on condition, a different type of possessory estate. The fee on condition is one of those defeasible fees. It is an interest subsequent to a condition precedent, or defeasible because it's subject to a condition subsequent. And we'll have to understand what the difference is between those two things. It is perhaps best understood as being a kind of a combination of 2 estates that existed at common law, which you may remember from your bar prep courses. The fee simple subject to executory limitation. These are all our old favorites from 1L property law, perhaps from a trust and estates course that you may have taken, and certainly from preparation for the bar exam. It's something that bar examiners like to test on. So to recall, the fee simple subject to condition subsequent is a possessory estate followed by a future interest in the grantor. And it typically takes the form of to A, provided that A never sells liquor on the premises, right? This is a grant from the original owner of a fee simple to someone else, subject to some condition, such that if the condition is later triggered, somebody other than the recipient of the original possessory estate is going to have a right to enter and take possession away from that original recipient. So this future interest in the grantor in New York is called a right of reacquisition. It is a right that at common law we would call the right of entry or the power of termination. It's a right that allows somebody else, if this subsequent condition comes about, to assert a right to possession and take the right of possession away from the owner of the fee on condition. Now, under New York law, because these kinds of interests can hover and kind of hang like a sort of Damocles over the head of the owner of the fee simple, of the fee on condition, New York makes it difficult to retain this right to swoop in on the occurrence of some subsequent condition and take the right of possession away. New York Real Property Law Section 345 requires the owner of that future interest, the right of reacquisition, to renew that interest periodically over several periods. In fact, there's fairly narrow windows over fairly lengthy periods of time in which the owner of the future interest must take some action, file a document in order to preserve this future interest, the right of reacquisition. If they fail to do so, then the fee on condition becomes a fee simple absolute. The future interest that could take the right away disappears. So that's the way in which the fee on condition resembles the common law fee simple subject to condition subsequent. It also bears some resemblance to the fee simple subject to executory limitation at common law, which looks the same as the fee simple subject to condition subsequent. The main difference is who owns that future interest that can come in upon occurrence of a condition and divest the owner of the possessory estate. In the fee simple subject to condition subsequent at common law, it was the original grantor who had that right, or their heirs and assigns. In the fee simple subject to executory limitation, it was someone other than the grantor who held that right to swoop in and divest the original grantee upon the occurrence of some condition. In New York, we've done away with that distinction. We have only the fee on we would call that future interest a contingent remainder, or a remainder subject to conditions subsequent, where it is created in someone other than the grantor. In the example that you have here on the slide, we see a grant to A, but if A ever sells liquor on the premises, then to B. All right? The interest that A holds in that example is the fee on condition that we've been talking about. The interest that B holds, rather than being a right of reacquisition because it's not created in the grantor of this interest, is referred to as a contingent remainder, or a remainder subject to a condition precedent. At common law, we would call it an executory interest, but New York has combined these two things. The thing to note about the future interest that follows this fee on condition is that it doesn't take effect automatically by operation of law. That is, the owner of the future interest, whether it be the right of reacquisition or the contingent remainder, that owner has to take some legal action upon occurrence of the condition set forth in the original grant to assert their right to possession. Essentially, they have to file a lawsuit to take title from the owner of the fee on condition. Now, this is an awkward and cumbersome and problematic form of ownership, and it is largely disfavored today. We inherited it from the common law, but you are unlikely to encounter it in modern residential real estate practice. But because this is a refresher course on basics, we are going through the basics, the foundational system of estates in land. Moving on to the third form of estate classified as to duration in Section 6.1.1 of the EPTL, we come to the fee on limitation. Now, the fee on limitation is somewhat similar to the fee on condition, but instead of being defined by the occurrence of some condition, it is defined by some period of duration. It is different, however, from a leasehold estate because that period of duration is potentially defined in turn by the occurrence of some condition. And it is only the language of the grant invoking language of duration that leads us to conclude that we are dealing with a fee on limitation rather than a fee on condition. So if you look at Professor Turano's practice commentaries, she explains that the fee on limitation is an interest that continues for a stated duration created by words that denote time, such as during, or as long as, or until, or while. When a grantor creates a fee on limitation without any gift over, some subsequent transferee who will take the right to possession when this duration terminates, then that interest is retained by the original grantor. We call that retained interest a possibility of reverter. If there is a gift over again, we call it a conditional remainder, or a remainder subject to a condition precedent. Now, the fee on limitation under New York law is the analog of the common law fee simple determinable, and again, it's followed by this future interest. Somebody has to be able to take when this determined period ends. At common law, if the future interest was retained by the grantor, we called it a possibility of reverter. At common law, if we saw this future interest created in someone other than the grantor, there was some dispute at common law whether it was properly thought of as an executory interest or rather a possibility of reverter. But in any event, in New York, we don't have to worry about that. Again, the terminology in New York calls the future interest retained by the grantor following a fee on limitation a possibility of reverter, just as it's called at common law. If the future interest is given to someone other than the grantor, it is called a remainder subject to condition precedent. Again, all of these remainders, or these contingent remainders, take the same name under New York statutes. Now, the big distinction between the fee on limitation and the fee on condition is that, unlike the right of reacquisition that we just talked about following the fee on condition, the future interest that follows a fee on limitation becomes possessory automatically upon the occurrence of the condition that terminates or limits the fee on limitation. So in an example analogous to the example from our previous slide, for example, we might say that O would grant Blackacre to A so long as liquor is never sold on the premises. That so long as language is language of duration. It creates a fee on limitation. And if nobody is designated to take possession upon the occurrence of this condition, the grantor would retain a possibility of reverter, which would take effect automatically in the event that the condition was breached, in the event that liquor was ever sold on the premises. Now, like the future interest following the fee on condition, the future interest following the fee on limitation must be renewed under Section 345 of the Real Property Law in order to remain effective. Again, if the owner of that future interest fails to renew according to the terms of that statute, the fee on limitation, like the fee on condition, converts into a fee simple absolute. The future interest goes away. There is no limit on the possessory estate. Again, because this is such a weird historical artifact, you're unlikely to encounter it in modern residential real estate practice. All right, so if there are no questions about these three forms of estate, which there don't seem to be yet, we'll turn to the life estate. Now, this is one of those common law estates which you may, in fact, encounter in modern real estate practice. The life estate, or the estate for life, is a possessory estate, freehold estate, that lasts for the life of its owner. The life tenant's interest ceases upon their death. Upon the death of the life tenant, title automatically passes by operation of law to the owner of whatever the next interest is. If the next interest was retained by the person who created the life estate, it is a reversion in the grantor. If the grantor who created the life estate has designated someone else to take possession after the life tenant's death, that future interest is called a remainder, and you can find these terms in Section 6.3.2 of the Estates, Powers, and Trust Law. Now, the reason you're more likely to find a life estate than any of these other types of exotic possessory interests that we've been talking about is because they are often used as an estate planning tool and as a will substitute, or at least sometimes. They are not the best vehicle for this. In modern practice, trusts are more flexible, especially for estate planning purposes and for probate avoidance purposes, but you do still see them from time to time. Now, if you're ever asked what the implications are of creating a life estate instead of using one of these other forms, be cautious. The tax implications can be very, very complicated when comparing, for example, a trust to a life estate followed by a remainder to simply devising real property by will. But you will often see these kinds of life estates used as a way of planning intergenerational ownership of real property. The family home will be held by the surviving spouse as a life tenant with a remainder to that spouse's children. There are other issues, other reasons why you might see a life estate being created rather than a trust or a devised by will, and those can have to do not with taxes but with qualification for certain benefits that are typically sought by the elderly. For example, in order to qualify for Medicaid nursing care benefits, there are certain wealth caps, and the valuation of a life estate is different than the valuation of a fee simple absolute. It's far less. So you will sometimes see elderly homeowners carving out of their own fee simple absolute a life estate retained by themselves, followed by a remainder in their children or in somebody else. Again, these are complicated arrangements. If you encounter them, you would be well suited to contact an expert in those kinds of arrangements before messing around with them too much. So, back to the basics of the life estate. There are limits on what the life tenant can do with their ownership interest. A life tenant cannot alienate or encumber the future interest that follows them, that is the remainder or the reversion, without the consent of the owner of that future interest, the remainderman or the original grantor. So there are limits in what the life tenant can do. They cannot get a mortgage on the fee simple because they don't own the fee simple. For example, they own only their life estate. And conversely, creditors cannot look to the remainder interest or the value of the fee simple as a whole in order to satisfy the or attach only the life estate. Conversely, again, the owner of the fee simple can't deprive a mortgagee of their security interest in the fee simple by conveying a remainder and retaining a life estate the way that we've just seen some elderly homeowners may want to do. Any conveyance out of the encumbered fee simple absolute will be subject to that mortgage unless the mortgage is discharged and satisfied. So it will be subject to this pre-existing mortgage on the fee simple. Now, I see we have a question here. So the question is, what happens to tenants of a life estate holder when the the Hornbook answer is, again, that the life tenant cannot convey any more than what they have. They cannot encumber, without the consent of the owner of the reversion or of the remainder, any part of that reversionary or remainder interest, which means that somebody renting from a life tenant is taking a risk that the life tenant will die before their lease terminates. The best practice in that kind of a situation is for the tenant under the leasehold interest to get the signatures of both the life tenant and the remainderment, or both the life tenant and the owner of the reversion. And of course, this is another one of those reasons why a life estate is not necessarily the best tool for these kinds of estate planning purposes. Far more flexible is the trust, again, where the trustee has the sole legal authority to enter into these kinds of arrangements with respect to land, and any of the income can be channeled to whoever the appropriate party is. I hope that answers the question. Next question, does that mean if someone receives a property on death via life estate, they have to pay taxes on the property? So again, this is one of those areas where thinking like a lawyer really, really matters. So for example, lawyers don't say that you own the property, you own a certain estate in the property. If the decedent is a life tenant, nothing of theirs passes to the remainderman or to the owner of the reversion. The owner of the reversion does take some interest, but that interest is taken by the instrument that created the life estate and reversion or life estate and remainder arrangement in the first place. If there's going to be a taxable event, that is likely to be it. Though, again, you ought to consult an estate tax attorney when dealing with these kinds of issues. You ought not to counsel clients to enter into or to convey and create a life estate followed by a remainder, or to convey a life estate and retain a reversion, or to convey a remainder and retain a life estate without consulting a qualified attorney on the tax implications of it, and particularly the tax implications of it compared to the implications of a trust or another form of ownership. All right, so moving on. Good questions, and thank you for those. Moving on, we are now moving from estates classified as to their duration when they end to estates classified by the number of people who own them. And this is the category of concurrent interest, which some of you may be familiar with if you ever deal with clients who are married and own interest with their own real property interest with their spouses. You've probably encountered one of these forms of ownership. So the 4 forms of ownership are classified according to the number of persons that we have in New York under Section 6.2.1 of the EPTL are ownership in severalty, joint tenancy, tenancy in common, and tenancy by the entirety. The tenancy by the entirety is a specific form of ownership for married couples that applies only to real estate and to residential co-ops. So beginning with the first, ownership in severalty, this is just individual ownership. This just means that there's only one person who owns whatever interest or estate is at issue, whether that interest be a fee simple absolute or a life estate or whatever else. When it's owned in severalty, that means it's owned by one person. So that's a pretty simple one. Moving on to the joint tenancy, this one is extremely common. The joint tenancy is a form of concurrent ownership among 2 or more persons that is characterized by the right of survivorship. So the right of survivorship means that when one joint tenant dies, their interest in this jointly owned estate disappears, and the remaining joint tenants simply absorb that interest. If there are 3 joint tenants and joint tenant A dies, joint tenants B and C move from having a 1/3 interest as joint tenants to having a 1/2 interest as joint tenants. If B then dies, C moves from having a 1/2 interest as a joint tenant to owning the entire thing. This is another common will substitute or probate avoidance estate planning tool. If a husband and wife, for example, own their home as joint tenants with the right of survivorship, when one of them dies, the other simply owns the home outright. There is no need for a will. There's no need for any action to be taken. The right of survivorship means that the surviving joint tenant will take sole ownership by operation of law. So that can be attractive as an estate planning or probate avoidance tool, and it's a fairly common one historically. The right of survivorship, however, can be defeated, and can be defeated unilaterally by one of the joint tenants by what we call severance. Severance is an act taken by one of the joint tenants to sever the joint tenancy, converting is to bring a partition action where you are seeking either physical partition of land or partition by sale of jointly owned land, where you're going to sell the entire parcel and divide up the proceeds according to shares. Such a partition will also have the effect of severing the joint tenancy, converting it to a tenancy in common. Now, this could create a problem if, for example, a joint tenancy is a form of estate planning, particularly for a couple or a family arrangement or what have you, and that is that one party to this joint tenancy could sever without the others knowing, and that could throw some of their estate plans into disarray and have really deleterious consequences. The effort to avoid that kind of surreptitious severance is reflected in Section 240C of the Real Property Law, and that is that if you are going to sever unilaterally by conveying, for example, your interest in a joint tenancy to yourself, that severance isn't going to be effective unless you then record that instrument so that it's a matter of public record. So if they wanted to, the other joint tenants could find out about it, recording it prior to the death of the severing joint tenant. And this is a way of preventing that kind of surreptitious unilateral severance. Again, unilateral severance is still permissible, but there has to be some way that the other joint tenants can find out about it, for example, through the public record. Now, if we are dealing with a joint tenancy between a married couple who could own in any form of concurrent ownership, and they're the only ones who can own by tenant, couples own real property as joint tenants with the right of survivorship. If they do and they get divorced, that divorce does not automatically sever the joint tenancy. They continue as a divorced couple to own as joint tenants with the right of survivorship unless they have taken some action to sever. That action could be reflected in a divorce decree. For example, a divorce decree as part of the allocation of the property of the marriage could decree that the joint tenancy is converted into a tenancy in common, but it need not do so, and so that's something to pay attention to. So we have another question here. Are there any known defenses to stop partition? So a partition is not something that we were going to cover in any great detail today, but a partition action is a form of action that can be brought by any concurrent owner in either a joint tenancy or a tenancy in common, not a tenancy by the entirety for reasons that will become apparent soon. But a joint tenant or a tenant in common can bring a lawsuit to partition jointly owned property. That is, the partition could take the form of either a judicial sale or a forced sale of the property, where the proceeds of the sale will then be divided according to shares among the concurrent owners, or a court could appoint a master to do a survey and physically divide the land and allocate a portion of the land to each of the concurrent owners in fee simple absolute in severalty. The partition action is an action that is available as of right to either joint tenants or tenants in common. You cannot stop a partition from happening. That is because the law generally favors severalty ownership, which is easier to deal with and to market than joint tenants or either tenancy in common. There are arguments that you can make to try and convince a court that a partition in kind, that is a physical partition, is more appropriate than a partition by sale, for example. And of course, in a partition by sale, it is possible for one of the concurrent owners to buy out the other, though of course that would be better done through negotiation rather than through litigation. But in general, no, there is no way to prevent any concurrent owner from obtaining a partition if they really want it. And I hope that answers the question. All right, so moving to the tenancy in common. The tenancy in common is kind of the default form of concurrent ownership. It is the one that you're most likely to find where we're not dealing with a situation that involves estate planning or family planning or anything like that, or probate avoidance. The tenancy in common is simply the default plain vanilla concurrent ownership arrangement. Each tenant has a separate fractional but undivided interest in the whole, and accordingly each tenant has a right to possession of the whole. Now this can be tricky to get your mind around because in one view, tenants in common own shares in real property, but in another view, they each individually own the whole of the real property, and it's important to tease out the implications of this. Rather than going into the various common law mental acrobatics that were involved in coming up with this kind of arrangement, I will give you a basic rule of thumb that is a good way of understanding how this breaks out when we're dealing with an actual tenancy in common. And that is that each co-tenant's interest, when we're dealing with a tenancy in common, we call the individual joint owners co-tenants to distinguish them from joint tenants. Each co-tenant's interest is fractional insofar as it applies to things about money. Income from the property, for example, from rent, expenses of maintaining the property, proceeds of selling the entire property, and so forth. There are some complications to that, but in general, when we're talking about the fractional ownership shares of co-tenants in a tenancy in common, you own 1/3, B owns 1/3, C owns 1/3. That means they have a right to a 1/3 share of any proceeds and an obligation for 1/3 share of any expenses involved in the concurrent ownership arrangement. But with respect to the kinds of rights of ownership that don't have to do with money, the right to possess the real property, the right to exclude others from the real property, the right to use the real property, for example, those rights are undivided. We don't have the Brady Bunch situation where we draw a line down the middle of the room and we say, that's my side and that's your side. That's not how co-tenancies and joint tenancies and tenancies by the entirety work. Each concurrent owner has the right to possession and use of the whole, meaning that if there are fights between them that they don't agree on how best to use the property, you may find yourself pretty quickly moving towards a partition action if the parties can't agree on how to allocate those rights among themselves peaceably. So the question I have is, if the form of ownership is not specified in the deed, is the default tenants in common or joint tenants? You're anticipating the next slide, which we will get to in just a second once I get to this last point, which is simply to say that each tenant's interest in a tenancy in common, unlike the joint tenancy, which disappears upon the death of the joint tenant, each tenant's interest in a tenancy in common can pass not only by a grant during the owner's life, but by devise in a will, or by descent through the laws of intestate succession. That is something that survives the concurrent owner, the co-tenant. So moving on to the question, I'm sorry, we'll get to the question once we get past the tenancy by the entirety. So sit tight, and we'll get to that question about what the default interests are created in a conveyance to more than one person at the same time. Before we do that, let's talk about the tenancy by the entirety. So the tenancy by the entirety is a form of joint ownership or concurrent ownership that's only available to married couples. It looks a lot like a joint tenancy in that it has the right of survivorship. Each has a right to ownership of the whole upon the death of the other spouse. But unlike a joint tenancy, tenants by the entirety cannot unilaterally sever. They cannot unilaterally defeat their spouse's right to survivorship. They cannot unilaterally convey their particular interest and the interest of their spouse. They can, in New York, convey certain rights with respect to their particular interests, which we'll get to in just a second, but they cannot sever and they cannot defeat the rights of survivorship, at least not during the marriage. Nor can a tenant by the entirety bring a partition action, again, at least not during the marriage. Until the marriage ends, the married couple is bound in this concurrent ownership arrangement just as they are bound by the marriage itself. Which means that once the marriage ends, the tenancy by the entirety has to cease. It has to become something else. So when a married couple divorces, any property that they own as tenants by the entirety converts to a tenancy in common by operation of law, unless the divorce decree specifies otherwise. So we'll come now to the question that was asked earlier. When we've got a conveyance of real property of more than one person at the same time, to Jack and Jill, for example, and the instrument or the deed doesn't say anything about what form of ownership they're going to take, we're left with a bit of a dilemma. We don't know exactly what of these forms of concurrent interest that we've been reviewing we're going to be dealing with. And fortunately for us, the statutes in New York provide us with some default rules that tell us which form of ownership we're going to be dealing with in any particular situation. So Section 6.2.2 of the Estates, Powers, and Trust Law sets forth these default rules, and we'll go through them in some detail. Excuse me. So the first of these default rules is that a disposition of property to two or more persons creates in them a tenancy in common unless it's expressly declared to be a joint tenancy. Thus, in answer to the question that we arrived at, that we saw earlier, the default is a tenancy in common, unless one of these other default rules that we'll get to in just a minute is triggered. But in general, if you've got a disposition or a grant or a conveyance of property to two or more people and it doesn't specify what form of ownership they're going to take, the law presumes it's a tenancy in common. Exception, 6.2.2b. A disposition of real property. Now note, Section A was not limited to real property. It could include personal property. But Section B is limited to real property. A disposition of real property to a husband and wife creates in them a tenancy by the entirety unless expressly declared otherwise. So if we are conveying real property to a married couple and the deed of conveyance doesn't specify what form of ownership they are supposed to take, the fact that they are married at the time that the deed is executed and delivered to them creates this rule that they are going to take as tenants by the entirety. Again, unless the deed says otherwise. The deed could say to Jack and Jill, husband and wife, as joint tenants with the right of survivorship, or to Jack and Jill, or Jack and John, I guess now in New York, as tenants in common. All right, so moving on. Subsection C and D have to do with conveyance of co-ops. Co-ops are treated a bit differently than other forms of real property ownership in lots of areas of New York law. We're not going to deal with those fine distinctions today, other than to note that conveyance of a co-op is treated like conveyance of real property. And so if the conveyance of a co-op is to spouses, then it's then it creates in them a tenancy by the entirety. If it's in people who are not spouses, it creates a joint tenancy unless expressly declared otherwise. So this is an exception to the default rule that conveyance of real property to two or more people at the same time creates a tenancy in common. If the property at issue is a co-op unit or shares in a cooperative, residential cooperative corporation, then the form of ownership is presumed to be a joint tenancy with the right of survivorship. Subsections subsections E and F pertain primarily to transfers of property at the death of the previous owners. It may be, for example, that a will designates more than one executor, or that a deed of trust designates more than one trustee. In those circumstances, the executors or trustees act as joint tenants. And again, note, this is not something that can be specified otherwise. This is just the default form of concurrent ownership of executors, trustees, and guardians. Similarly, if we've got property passing by intestate succession, where, for example, it was owned by somebody who has died without a will, often the rules of intestate succession will divide up ownership among multiple persons, multiple children, for example. The default rule there is that the multiple owners who take by intestate succession acquire interest as tenants in common. All right. Any questions regarding the matters that we've just gone through? I think I answered the last question with this slide. And if not, we can move on. All right. So of particular interest to foreclosure advocates is what rights creditors, and in particular mortgagees, have against multiple owners of concurrently owned real property. It may be that you've got a mortgagee, for example, who entered into a mortgage with only one of several concurrent owners of real property. Now, if they did that, they're going to find themselves in some trouble for reasons that we're going to go through. And more to the point, you ought to be aware, if you ever find yourself representing a client who has an issue with a mortgage which encumbers concurrently owned real property, you have to be aware of the complicated lines of responsibility and of right that can arise in these kinds of situations. So the first rule that we'll deal with is that any tenant in common, right, any co-tenant, can unilaterally convey or encumber their own interest, but they cannot affect the other co-tenant's interests. Right? You cannot, if you're a concurrent owner, you can convey your 1/3 share to somebody else. You can give a mortgage on your 1/3 share, but you cannot, with that mortgage, change the rights of your co-tenants to their shares, their 1/3 shares, for example. Which means that the mortgagee, or the creditor of that one mortgaging co-tenant, cannot reach the shares of the other co-tenants, cannot encumber them, cannot foreclose on them without their consent. And typically that consent would be participation in the mortgage loan in the first place. All right, so this is an important feature of these kinds of concurrent ownership arrangements. That is, one concurrent owner cannot encumber or otherwise affect the rights of the other concurrent owners without their consent. In New York, that is also true of joint tenancies. And that means that creditors have to be careful. New York follows what we call the lien theory of mortgages. A mortgage is not thought of as a conveyance of an interest in real property. It is thought of as the creation of a lien on real property, and that distinction has some significance. That means that a mortgage by one joint tenant, first of all, doesn't sever the joint tenancy. It doesn't defeat the right of survivorship. It means that, for example, we haven't had a situation where one joint tenant has conveyed their interest to themselves, thereby severing the joint tenancy. They've unilaterally entered into a mortgage on this jointly owned property. Well, that's fine, but it can, again, affect only their rights. They haven't defeated the right of survivorship. They haven't severed the joint tenancy, which means if that one mortgaging joint tenant dies first, the non-mortgaging joint tenant owns the real property free and clear of the mortgage. The mortgage simply disappears along with the interest that it encumbered. You will typically not see sophisticated creditors, banks for example, entering into these kinds of mortgage loans to just one of multiple joint tenants with the right of survivorship. They will typically insist on getting the participation of all joint tenants in exchange for the mortgage loan. But it is possible, it has happened, that creditors have secured a mortgage of only one joint tenant, and that joint tenant has then predeceased the other, and that results in the disappearance of the mortgage. However, if you are in a situation where the creditor has taken a mortgage on just one joint tenant's interest, and either the mortgage loan defaults prior to the death of that one mortgaging joint tenant, or the other joint tenant dies first, the non-mortgaging joint tenant dies first, then the creditor is okay. They can foreclose on the interest of the joint tenant during their lifetime, and they can certainly foreclose on it when that joint tenant has acquired the entire interest in the property via the right of survivorship. If they do so, again, once they acquire that interest, for example, through foreclosure, they can then sever or partition or do whatever they like with that interest as the owner of the foreclosed interest. All right. If we have no questions so far, we will move on to the far more complicated circumstance of the tenancy by the entirety. So the tenancy by the entirety, as you know, is a form of ownership that exists only between married couples. In general, they can jointly decide to convey or encumber the entirety property. They can jointly take out a mortgage loan on their property. They can jointly convey their property to somebody else. And according to this case decided by the Court of Appeals some 30 years ago, VRW versus Klein, a tenant by the entirety can unilaterally convey or encumber their own interest. But that conveyance or that encumbrance is going to be subject to certain indefeasible rights of the non-conveying spouse. Right? In particular, the possessory rights and the survivorship rights of the non-conveying spouse. If that spouse doesn't consent to the conveyance or to the mortgage or other encumbrance, then their survivorship and possessory rights cannot be defeated. Which means that if, for example, we have husband and wife, and husband has incurred certain debts and the creditor of the husband wants to levy against the entirety property, they can do that, but if the creditor did not, but if the other spouse, the wife, for example, is not a party to those debts, the creditor cannot look to that non-debtor spouse's interest in the entirety property in satisfaction of the debt. Which means that if they then levy against or even foreclose on the debtor spouse's interest, they're going to take whatever that interest is, subject to all the possessory rights of the wife, for example, and the survivorship rights of the wife, which is not really a very marketable asset, frankly, and why entirety property is not particularly attractive in satisfaction of other unsecured debts. So I have a question here, a strange situation. All right, I'll do my best. In this strange situation, husband and wife A conveyed property to husband and wife A, and husband and wife to themselves and another couple. Weird, right? Yeah, I'd say that's pretty weird. So husband and wife A are the ones on the note and mortgage. Can the bank foreclose as do husband and wife B? So it's going to depend on when the mortgage was executed. For example, if the mortgage was executed prior to this conveyance by couple A to couples A and B, then the conveyance to couples A and B would have been subject to that mortgage. And you ought to check the mortgage instrument because it might have had a due on sale clause or another kind of acceleration clause that would make the amount due under the note due and payable upon the date of that transfer. So that might be complicated. If not, if, for example, the bank extended this mortgage loan to couple A alone without securing the agreement to be bound by couple B after ownership had passed to couples A and B jointly, then again, because I assume because we've got A and B jointly owning this thing that they can't own it as tenants by the entirety because they're not one spousal unit, that they must own it as joint tenants or tenants in common. And if that's true, then certainly the interest of couple A could be reached by the creditor, but possibly not couple B, although I would probably want to get more facts from you about that particular situation. It sounds, frankly, like the kind of question I might ask my students on a law school exam in first-year property. If there are any other questions with reference to either the estates and land or the forms of concurrent ownership, now would be a good time to ask them. I'll give everybody a minute, just a quick minute, to put in any questions that you have. I'll take a little drink of water, and then if there are no other questions, I'll move on to deeds and transfers. Okay, so seeing no other questions, we'll move on. So one of the things we have to look at is how ownership changes hands from one party to another, because those kinds of transactions are often going to be important to determining rights of ownership and whether creditors have rights against particular parties. So we'll deal with a few different forms of transfers. There are operation of law. We've seen a couple of those already, but we'll go into it in some more detail. There are transfers by devise, that is transfers via a will that enters into probate and is executed and the terms of the will. There are transfers by descent. When somebody dies without a will, their property is distributed according to the laws of intestate succession. And there are transfers by deed, which are the most common ones, which are the ones we're going to be focusing the most on. So those are voluntary transactions between living people. So beginning with transfers by deed, I'm sorry, not beginning with transfers by deed, beginning with transfers by operation of law. Transfers by operation of law can happen in multiple situations, some of which we've already seen. When a life tenant dies, for example, the owner of a life estate or an estate for life, when they die, the owner of the next interest, whether that's a reversion or a remainder, automatically becomes the owner of the fee simple absolute. That is, they take possession by operation of law. Nobody has to go to court. Nobody has to bring on. Ownership simply passes by operation of law. The same is true for the occurrence of a limiting event that signals the end of a fee on limitation. Again, ownership transfers by operation of law, provided again that the owner of the future interest following the fee on limitation has renewed it according to the terms of Section 345 of the Real Property Law. Similarly, when a joint tenant dies, their interest disappears by operation of law. No new paperwork needs to be filed. No lawsuit needs to be brought. The surviving joint tenants simply absorb that interest, and they are now the owners. Similarly, with respect to entirety property, when one spouse dies, the other spouse becomes the sole owner by operation of law. No paperwork needs to be filed. No lawsuit needs to be brought. So those are the simpler transfers. They may later need to be documented. For example, if the surviving spouse or the surviving joint tenant wishes then to pass title in a bargain for transaction, they will typically append as an attachment to the deed and the other documentation of the transaction, they will append some satisfactory proof of the death of the joint tenant or of the spouse. But apart from that, nothing else needs to happen for title to pass. And we've seen these, each of these before. So, transfers by devise. This is by will. Typically, a transfer by devise results from the death of somebody who has a validly executed will, and certain results will follow upon the death of somebody who left a will, a valid will. Probate court register the will. The will will be examined. It may be contested. And ultimately, the result will be the issuance of letters testamentary. The executor will take this instrument from the court that will vest them with the authority to dispose of the decedent's property according to the terms of their will. When they do so, they will execute an executor's deed transferring the property as directed in the will. And that's a special form of deed that we will see in just a moment. Transfers by descent work a little bit differently, but they're pretty analogous. When somebody dies without a will, the court will appoint an administrator of their estate who is responsible for administering the estate according to the laws of intestate succession. The administrator will be issued letters of administration by the court, which will vest them with the authority to dispose of the estate's property according to the intestate succession rules. Again, pretty straightforward. We come then to the most common form of transfer, deeds. These are voluntary transfers, typically in bargain for transactions between living persons or persons and entities. And Section 258 of the Real Property Law sets forth a number of statutory short forms that are going to be valid as means of conveying interest in real property throughout the state. And because the statute says they're valid, they are the preferred instrument for these kinds of transfer. There are a bunch of instruments set forth, or form instruments set forth in Section 258, and they can be distinguished into a couple of factors. One is whether the grantor is an individual or a corporation. There are separate forms for each, and separate forms of each of the next sort of distinguishing feature according to whether it's an individual or a corporation. The second primary way that deeds are distinguished from one another is according to the covenants in the deed. The covenants are a form of protection for the purchaser or the grantee against any defects in title. There are 4 different types of covenants set forth in the statutory forms. There's the deed with full warranties. There's the bargain and sale deed with covenants against the Grantors Acts. There is the bargain and sale deed with no covenants, and there is the quitclaim deed. And we're going to go through each of those in some detail in just a moment and how they differ. Excuse me. There are other forms that you'll see in Section 258 that are special for referees and partition. There are instruments, statutory form instruments for mortgages, for releases, for satisfactions, and for assignments. There's a lease assignment form in there. But in general, we're going to be focusing on the deeds today. So when we distinguish deeds according to the warranties that are in them, these warranties are largely going to be relevant when a situation arises such that there is some cloud on the grantee's title. And so the warranties have to do with the guarantee of title by the grantor to the grantee. A deed with full covenants contains the 5 covenants that you've seen here, which are promises that the grantor or seller is making to the grantee or purchaser. The first is that the grantor is seized of the premises being conveyed in fee simple and has good right to convey the same. That is, I own this. I own this thing that I'm selling to you. The seller need not make such a representation, but in a deed with full covenants they do. Second, that the grantee shall quietly enjoy the said premises. And this is a covenant that basically promises that nobody is going to assert superior title to the grantee. Right? Third, that the premises are free from encumbrances, that there are no encumbrances burdening the title that the grantee is taking under this deed. Now, typically, this covenant will be qualified by a limitation or subjecting it to any easements, covenants, or restrictions of record. All that means is that if, for example, there are covenants by virtue of a homeowners association or a condominium declaration or so forth, equitable covenants that restrict the use of the real property that appear on the face of the title records, those are going to be accepted from this covenant against encumbrances, and that's pretty typical. What we're talking about here mainly is undisclosed mortgages, things like that. Fourth, that the grantor will execute or procure any further necessary assurance of the title to said premises. If someone comes in and asserts some defect in title that the grantee has taken, and that defect in title could be cured by some act of the grantor, they are covenanting to do so. For example, to obtain a quitclaim deed from some party whose quitclaim is necessary to remove a cloud on title, and we'll talk about quitclaims in just a second. And fifth, the covenant of general warranty, the covenant that the grantor will forever warrant the title to said premises. That means if a defect in title later arises, the grantor is essentially promising to make the grantee whole for that defect in title. All right, before we move on, I see a question. Do deeds need to reflect the ownership interests held by grantees in order for those ownership? Not exactly clear on what you mean by this question, but typically the deed must have a description of the property being conveyed. So, for example, 123 Main Street, and there will be in New York City, for example, more thoroughly a legal description according to borough block and lot number, or perhaps according to a survey, or according to some meets and bounds description of the real property. That's the physical real property. If the deed recites some legal property, for example, my 1/3 interest as tenant in common in 123 Main Street, then again, the deed must have a description of what exactly is being conveyed. If the description is ambiguous, for example, it might be the case that the grantor owns a large parcel and they're purporting to sell only a portion of it, and that description may be ambiguous, there's probably going to be litigation to figure out what exactly the description is referring to in the real world. If, for example, we are dealing with a situation like we've been talking about with concurrently owned property, and one concurrent owner is purporting to convey their interest, typically the deed will recite that the grantor is conveying all my right, title, and interest in the described property, 123 Main Street or what have you. And then that would be just everything that the grantor owns with respect to that property. If there's any further ambiguities, typically they would end up in litigation that would have to construe the deed. But without any more specific example, I'm not sure that I can give a more specific question, but I hope that answers the question. So we've talked about the covenants of title that occur in a deed with full covenants. There are lesser forms of warranty that can be set forth in a deed, including statutory form deeds that appear in Section 258. So the first of these is a deed with a covenant against grantor's acts. So typically, this is a deed wherein the grantor represents, promises, that not done or suffered anything whereby the said premises have been encumbered in any way whatever. This is a way for the grantor to represent that they have not themselves been responsible for any defect in title, but they are not representing, for example, that prior to the time that they acquired an interest in the property, there might have been some cloud on title that would persist to the present day. So I will promise that I have not myself taken out any mortgages that I'm not accepting from the covenant against encumbrances that you don't know about. But I'm not promising that, for example, somebody who owned this property before I did took out a mortgage that was never satisfied, or that there might be some other encumbrance. And this is a way of limiting the grantor's exposure, while still providing some warranty that the grantor is not selling essentially a bill of goods or a clouded title to the grantee. Finally, we have the bargain and sale deed and the quitclaim deed. These are two forms of deeds with no covenants whatsoever. The bargain and sale deed has to recite and to be supported by so-called pecuniary consideration. That is, the deed will recite that the grantee is accepting this title in exchange for good and valuable consideration, for example, $10 and other good and valuable consideration. A quitclaim deed does not have to have that kind of a recitation. A quitclaim deed could be a gift. The form quitclaim deed does recite consideration in Section 258, but it doesn't have to. The reason why you might want to give and recite pecuniary consideration is because that type of consideration is required for the grantee to enjoy the protections of the recording statute, the protections that go with a good faith purchaser for value. And we're going to be talking about those towards the end of our time today. But that is the primary distinction between the bargain and sale deed and the quitclaim deed. The bargain and sale deed must recite consideration. The quitclaim deed may but need not. And in either case, the grantor is not making any warranties or covenants regarding the state of title. Next question. Is the bargain and sale with covenant against grantors acts the most common default form of deed in New York? Well, that's an empirical question. I just don't know. I suspect it is quite common. I've seen them a lot in the title records when I've been fishing through the title records in New York City, but I don't know whether it is the most common. And I can't give you any more than that. Typically, the deeds with covenants are more common than deeds without covenants, but there are certainly just plain bargain and sale deeds and quitclaim deeds with no covenants out there in the title records in New York State, and you may find them. What that means, essentially, is that if an owner who has taken title under one of those deeds without covenants suddenly finds that their title is subject to some cloud, if there's some existing mortgage or some existing restriction that they weren't aware of, then they cannot look to their seller to make them whole for the loss of value represented by that encumbrance, again, unless they have acquired title by one of these deeds with a covenant. Okay, moving on. Forgery and fraud. As people in your line of practice probably know, there may be circumstances in which somebody who has either taken title under a deed or has taken title from someone who took title under a deed might have acquired that deed through shady dealings. And this is the situation of forgery and fraud. So we'll talk about fraudulently obtained deed is in just a moment. I find that in situations of foreclosure defense where, for example, you're dealing with elderly clients, there are very often allegations that your client will have executed a deed without realizing what it was, or will have had their title stolen from them through a forgery. We're going to deal with what exactly those circumstances are and what the legal implications of them are. So, first things first, a forged instrument is void. It passes no interest. Its grantee can pass no interest. Any chain of title tracing itself back to a forged deed is no good. It's invalid. Nobody in that chain of title has any valid title. A person cannot be a bona fide purchaser through a forged deed, even if somebody further down the chain of title had no reason to believe that there was any shady dealing anywhere in their chain of title, that a deed at some point prior to their acquisition in their chain of title was in fact forged, doesn't matter. They do not get the protections of a bona fide purchaser for value because the forger, again, had no title to convey in the first place. So then what does it mean for a deed to be a forgery? Well, we have the penal law's definition of forgery, which says that forgery is the false marking, completing, or altering of a written instrument with intent to deceive or defraud. So, for example, if somebody gets a homeowner to sign a document and then alters the document to give it a legal effect other than the legal effect that the document would have had when it was signed, that's a forgery to the extent of the change. If somebody writes down somebody's signature without their consent and without a power of attorney on a deed, that deed is a forgery. It has no legal effect. So those are the kinds of situations that will be a forgery. There might be other situations that would cause a deed to be void. For example, if or an instrument conveying an interest in real property to be void. So, for example, if the instrument reflects an illegal mortgage, for example, because the mortgage rate was usurious under New York state law, the mortgage instrument is invalid. The mortgagee under that instrument has no lien on the property and can pass no security interest in the property. There might be other situations you would come up with where there is simply no authority to enter into the transaction in practice. So, for example, if a nonprofit corporation is selling substantially all of its assets, they actually need court approval to do that in New York, and if they purport to do so without court approval, the instrument by which they've done so is void. It passes no title, and nobody in the chain of title from that instrument can acquire good title. This is to be distinguished, the situation of forgery is to be distinguished from an instrument that was obtained by fraud. Sometimes you'll see the language, the legal language, distinguishing fraud in the inducement from fraud in the factum. Fraud in the factum is forgery, that is, the fact, the instrument itself, is false. Fraud in the inducement is something else. Fraud in the inducement is where the document was signed by the grantor, for example. It was signed by them in the form in which it now appears, but they were induced to sign it through means or through some sort of efforts. Where we have such a deed that was obtained by fraud, the title under that deed is merely voidable. Not void, but voidable, which means that the grantor under that deed, for example, can sue the grantee under that deed to invalidate the deed. Right? The fraudster is liable to suit by the defrauded grantor, for example. But if the fraudster manages to avoid such suit long enough to pass title to a bona fide purchaser, a good faith purchaser for value who has no knowledge of the fraud and no reason to know about the fraud, that good faith purchaser can acquire good title even as against the defrauded grantor. All right, so this is a potential way of washing a fraudulent transaction in a way that leads to the defrauded party losing their real property interest to a good faith purchaser. The idea here is that somebody is going to get hurt. It's either going to be the original grantor who was defrauded or the good faith purchaser who had no reason to know that the title that they purported to buy was obtained through fraud. In those circumstances, the law, subject to the terms of the Recording Act, which we'll get to shortly, the law favors the good faith purchaser. All right, I seem to have a question. Oh, another law school exam hypo. Okay, brother and sister, both on deed and mortgage. Excuse me. Brother moved out of country. Servicer told sister that if she does a quitclaim deed and if both complete a family assumption package, they will, as both brother and sister agreed, just put the sister on the modification. She is on a trial modification plan, but has now been told that the brother will still be on the mortgage, and the only way to get him off is if the sister refinances. Any defenses being that all was verbal and not written. All right, if all is verbal and not written, then you're going to have a problem with the statute of frauds. All right, so all instruments conveying an interest in real property, including a mortgage, must be in writing. Right? And if not in writing, they are void. So that may be a problem if the client intends to rely on one of these oral agreements, excuse me, to modify a mortgage. Beyond that, It's not clear to me from the question who executed a quitclaim deed to whom. It seems that it may be that the sister quitclaimed in favor of either the brother or in favor of the mortgagee, and it's not clear from the question what the situation was. So I'm afraid I would have to have a little bit more clarification on what that situation is in order to be able to answer the question. All right, so as I can see, this issue of deed fraud is one that triggers a fair number of questions. Okay, another question. If a wife claims that someone forged her name on the mortgage, but the husband admits signing, could the mortgage be void against her? Absolutely. So again, if her signature was forged, the mortgage as against her is void and is of no legal effect. And in terms of what the effect of the instrument is as against the husband, we would need to know more about the circumstances under which the husband executed. If there may also be power of attorney issues in that kind of a situation that you would need to really investigate. Okay, any other questions about fraud and forgery, which we're going to come back to after we go through the recording statute, just to see how the two interact. But if there are any more questions, now would be a decent time to ask them. No? All right, so let's dig into the recording statute. This is a favorite subject of law school exams. It's something that can sometimes trip people up. Excuse me. On this slide, you see the New York recording statute, Section 291 of the Real Property Law. Section 291's structure provides for the recording of conveyances of real property and of interest in real property, including mortgages, in the office of the clerk of the county in which the real property is situated. There's also, for example, in New York City, there's electronic recording via ACRIS. All right. Every conveyance not so recorded is void against certain subsequent purchasers. What this means is that if you do not record a deed under which you take title, you are running the risk that some subsequent purchaser, without your consent, could obtain title in your real property. That is better than your title. The recording statute sets forth the conditions under which this will be true. And in that way, it sets forth the path that the purchaser or the owner of an interest in real property must follow to be secure in that interest against subsequent potential frauds or other types of clouds on their title. The first is that a subsequent purchaser can obtain superior title over an earlier purchaser who is not recorded if they are purchaser in good faith and for valuable consideration, right, from the same vendor or assigner or his distributees or devisees, and whose conveyance is first duly recorded. Right? So if somebody comes along and purchases land that you thought you owned but did not record your deed for, in good faith, for valuable consideration, and then records their deed before you record yours, their title is going to be better than your title. Your title is going to be void against them. All right? We can tease this out and to be a little bit more clear. We call this a race notice statute. Race because there is a race to record, and notice because the subsequent purchaser can only obtain superior title over the earlier purchaser if they lacked notice of that earlier purchaser's interest. All right, so a subsequent purchaser or subsequent mortgagee of particular interest to your line of practice, a subsequent purchaser will prevail over an earlier purchaser or mortgagee if the subsequent purchaser or mortgagee gave valuable consideration, they paid money, it wasn't a gift, if the subsequent purchaser or mortgagee acquired their interest in good faith, that is without notice of the earlier interest, and we'll talk about what that means in more particulars in just a moment, and if the subsequent purchaser or mortgagee wins the race to record, if they record the instrument under which they acquired their interest before the recording of the interest that preceded theirs that they're seeking to invalidate. Okay, so how does this play out in practice? One complicating factor is that the owner of the earlier interest may then subsequently seek to convey their interest, and then that conveyance may postdate the interest that is seeking to invalidate that earlier interest under the terms of the recording statute. Section 291 doesn't allow that to happen. It provides what's called the shelter rule. A purchaser from one who is protected by the Recording Act against a prior unrecorded conveyance is himself entitled to such protection, notwithstanding that he purchased with notice of the prior conveyance or without parting with a valuable consideration. What this means is that once somebody comes under the protection of the Recording Act and invalidates an earlier interest under the terms of the Recording Act, that interest and anybody in a chain of title from that interest is void. It becomes void as against the subsequent purchaser who obtained the protections of the Recording Act and anybody in that subsequent purchaser's chain of title, even if the people in the chain of title from the subsequent purchaser later find out, or even find out before they purchase, about this invalidated interest. Right? This is the shelter rule. It essentially settles the quality of the title under the Recording Act for all time. So, how does this play out in practice? We'll give you a couple of hypothetical examples. All right, two basic recording problems. One is on the left side of your screen, one is on the right side of your screen. All right, and we'll follow them in columns. So the first problem involves a mortgage. O mortgages to A, takes a loan out from A and gives A a mortgage. O then conveys to B, a good faith purchaser, meaning B has no knowledge of the mortgage taken out by A, but A hasn't paid off the mortgage, and for some reason this is happened without the knowledge of B and without the knowledge of A. Let's say A didn't record the mortgage prior to the conveyance to B. Then, after the conveyance to B, A records, and then B records. What would be the result under the New York recording statute? Well, in New York, because we have a race notice statute, A is going to prevail over B. B is going to own subject to the mortgage in favor of A. The reason why this happens is important. Note that B is a good faith purchaser for value. They gave valuable consideration, and they purchased without knowledge or notice of the mortgage to A, which you might think might give them the protections of the recording statute. But because New York is a race notice jurisdiction, B isn't protected against this mortgage to A unless B also records first, unless B also records before A records. A, on these facts, won the race to record, meaning that A's interest is good as against any subsequent purchaser for value, meaning that B has acquired this interest subject to A's mortgage. Now, B may have some claim against O, for example, for defrauding him into buying something that he thought he was buying free and clear when in fact it was encumbered by a mortgage. But as between A and B, A's mortgage has priority over B's possessory interest, and it encumbers that interest. Second example, O mortgages to A. O then conveys to B, a good faith purchaser. Then B records, then A records. Note that this fact pattern is exactly the same as the one we just did, except we have flipped the order of recording. Now the subsequent purchaser records before the earlier mortgagee records. In this circumstance, B has done everything they need to do to be protected against prior unrecorded interest. They are a purchaser for value. They purchased in good faith without knowledge or notice of the earlier mortgage, and they won the race to record. In these circumstances, B prevails and owns the property free and clear. Again, A may still have a claim against O for conveying this property without making it subject to the mortgage in a way that defrauded A of their ownership interest, but maybe not. It may depend on whether we think that there was some negligence on A's part. In any event, as a matter of the real property interests at stake, B prevails as against A. A's mortgage is invalid as against B. So one thing that we've got to figure out then is how you show that you purchased in good faith. If you're seeking the protections of the recording statute, you want to claim that you had no notice of this earlier mortgage, for example, and that your ownership of the real property should not be encumbered by that mortgage. You're going to have to show that you acquired your interest in good faith. So what does that mean? Well, we have some authority here from the Appellate Division and from the Court of Appeals. The Appellate Division tells us in a recent case that the status of good faith purchaser for value cannot be maintained by a purchaser with either notice or knowledge of a prior interest, or equity in the property, being a mortgage, or one with knowledge of facts that would lead a reasonably prudent purchaser to make inquiries concerning such. So, reasons why you couldn't claim that you purchased in good faith. One, the interest was recorded. The prior interest was recorded. If it was recorded, you're charged with notice of it. Two, you actually knew that this interest exists. It hadn't yet been recorded, but you had learned about it. Maybe your seller told you about it. You can't claim, if you had actual notice of it, that you lacked notice of it and that you purchased in good faith in the belief that there was no such prior interest. Third, and this is the tricky one, if you purchase with knowledge of facts that would lead a reasonably prudent purchaser to make inquiries concerning the existence of this prior unrecorded interest, then you can be charged with notice of that actual interest. Even if you were not actually aware of it, if you were aware of facts that might have led you to inquire, then you can be charged with notice of it and be deprived of the status of a good faith purchaser under the Recording Act. How does that work? The Court of Appeals over 100 years ago gave us some examples. If the facts within the knowledge of the purchaser are of such nature as in reason to put him upon inquiry and to excite the suspicion of an ordinarily prudent person, and he fails to make some investigation, he will be chargeable with that knowledge which a reasonable inquiry as suggested by the facts would have revealed. If something is fishy and it would lead a reasonably prudent purchaser or mortgagee to inquire as to the actual state of title and whether there is in fact some unrecorded interest floating around, and they fail to make such an inquiry, and we conclude that if they had made such an inquiry they would have discovered this prior unrecorded interest, they're going to be charged with notice of that prior unrecorded interest. They cannot claim to have purchased in good faith without notice of that prior unrecorded interest. But that presumption that they would have found it out can be rebutted. It can be rebutted with proof that the purchaser tried to find out, they did actually make some inquiry, and their inquiry was reasonably diligent, and nevertheless they failed to uncover it. If that's true, then they can still claim to be a good faith purchaser. Now, in your area of practice with forgeries and frauds and in particular ways, one of these facts that typically does give rise to this duty to inquire is where the seller is not actually in possession of the real property that they're purporting to sell, or the mortgagor is not actually in possession of the real property that they're purporting to mortgage. When that happens, the purchaser or the mortgagee is going to have some duty to inquire as to what the true state of title is and whether there is some potentially unrecorded interest or something wrong with the state of title of their grantor or their mortgagee. So, for example, if a purchaser had previous notice of the fraudulent intent of his immediate grantor or of the fraud rendering void the title of such grantor, the purchaser will not be protected by the Recording Act. For example, if there's a scheme, a kind of a deed fraud scheme where there's a pass-through or a middleman or a straw man, such that the person engaged in the fraud in the original transaction is not the person who's ultimately going to assert rights against the defrauded owner. They're going to defraud the owner and then sell in a wash transaction to somebody who's going to claim, I'm just a good faith purchaser. If that second purchaser is themselves in on the scheme, if they know about the fraud, they're not going to get the protections of the recording statute, and the title will be voidable as against them as well. Right? Moreover, courts will tend to follow the equities in these kinds of situations that look like fraud, look like they might be bound up in some fraud or some fraudulent scheme. They will follow the equities to avoid unjust enrichment from people who either were in on the fraud or really should have known better. So, for example, where Wells Fargo recently, in a case just a couple of years ago, Wells Fargo extended a mortgage on a property that was still in possession of a prior elderly grantor who alleged that she had been fraudulently induced to sign a deed as part of a foreclosure rescue scheme. Wells Fargo was denied summary judgment, even though they were not alleged to have been part of this scheme, but they extended credit and took a mortgage from somebody who was part of this scheme, because the elderly owner was still in possession of land that was being mortgaged by somebody else. So this is one of those ways that the intersection of the limits on title that result from forgery and fraud interact with the good faith requirement of the recording statute in ways that can be highly relevant to your areas of practice. This cuts both ways, though. So, for example, you may end up in situations where the fraud is on the seller or the mortgagor side. So, for example, if someone owns real property encumbered by a mortgage, and then they take 2 new mortgages on the property and intend to pay off the existing mortgage with one of those new mortgages, the 2 mortgagees may be so close together in time that the Recording Act could come into play, and in this case, Arbor Commercial Mortgage, the court applied the doctrine of equitable subrogation such that the second-in-time new mortgagee actually prevailed over the first-in-time new mortgagee who had not yet recorded, where the second-in-time mortgagee's loan proceeds were used to pay off the pre-existing mortgage that would have had priority over the first-in-time new mortgagees. It's a little bit complicated, but essentially the court looked through the strict letter of the Recording Act at where there was some bad faith and tried to prevent that bad faith from resulting in unjust enrichment at the expense of someone who acted in good faith. So that is, and we're coming close to the end of our time now, that is about all I have prepared for you. So if there are any other questions that I can answer regarding any of the materials that, that we've been through today, I'm happy to do so now. And if not, I'll turn it back over to our hosts and say thank you all for your time, and I hope that you found this helpful and informative.
Yes, so I feel like I'm back in law school. I'm getting those same jitters that I did back in property law class back then. So thank you, Jeremy, for putting me back in the state from many years ago. So those of you who loved it, kudos to you. I'm in awe. So I wanted to make sure people did get access to the CLE credits and participation codes. You should see that in the bottom right-hand corner in the chat box. I'm sorry, I'm apparently not able to open it up for some strange reason. There it is. Okay, so the CLE code is JL514. So just make sure you note that when you send us your CLE request. I think there's one more question from Justin.
Yes, Justin wants my email address, of course. You can have my email address. It is, I'll give you my St. John's email address. It's SheffJ, S-H-E-F-F-J, S as in Sam, H as in Harry, E as in egg, double F as in Frank, J, at St. John's, all one word, S-T-J-O-H-N-S, no punctuation, .edu. And feel free to free legal advice on any type of a situation you may be encountering in your practice, but I can certainly help consult on general questions of law. Oh, we've got one more question. Let's see. Does an unrecorded quitclaim deed A to B divest A of title? So one thing that I tell my students is it can often be unhelpful to think about these kinds of problems in terms of who owns Blackacre. Typically, the more fruitful way of thinking about it is as between A and B, or as between B and C, who has the superior claim to Blackacre. So if A gives a quitclaim deed to B, A cannot later claim that A has superior title to B. But that doesn't say anything about what A might claim against C, what A might claim against D, what B might claim against D, and so forth. So in order to be able to tell you, you know, in an unqualified way, whether A has been divested of title, I think for most practical purposes, the answer is going to be yes, if the deed was valid and validly executed and not tainted by any kind of fraud. But you know, it being a question that might be qualified by weird facts that students love to stump their professors with, I wouldn't want to say anything more definitive than that. Next question: Can tenant of A defend against eviction by A on the basis that A no longer has title to the property, even though the quitclaim deed was not recorded? Okay, so this is a complicated question that we would need to flesh out some additional facts on. But in general, if a landlord conveys their freehold interest during the term of a lease, the landlord cannot, without the consent of the tenant, interest, meaning that if somebody wants to buy the landlord's interest, they're going to be buying the landlord's reversion, the landlord's right to retake possession after the lease has run. If the question is, can the tenant defend against eviction by A on the basis that A no longer has title to the property, even though the quitclaim deed was not recorded, I think you know, the defense that seems to be being set up is that A isn't the owner anymore. And while that may be true as a matter of property law, it's not true as a matter of contract law. And leases are creatures of both contract and property. The tenant of A is still going to be bound by their contract with A. And A is still going to have their rights contract with the tenant. And those rights may be sufficient to retake possession from the tenant, notwithstanding that A has sold the reversionary interest, such that as a matter of property law, it would be the purchaser of A's reversionary interest who would have a right to proceed with eviction. I hope that's helpful.
Okay.
The general point is it's probably not a sufficient defense that the landlord sold the landlord's reversionary interest. Okay?
Okay. So I think, unless there's some other questions that come in the last few minutes, I will make just a quick announcement for the next couple of webinars that are coming. The next one is actually scheduled for June 8th, and I believe that the announcement will go out today, in fact. That one is called Stepping Stones to Self-Care. That is not a CLE, but it is, I believe that one's an hour and a half, and that one should be an interesting moment to just focus on the work that we do and making sure that we are looking out for ourselves so we can continue to help others. And then the next one is June 15th, the week after, and that one will be a CLE. We will have 3 presenters for that one covering most parts of the state, the end stages of residential foreclosure case, what happens after all is lost. So with that, Jeremy, you were fantastic. Thank you so much. Very engaging for a topic that some of us, specifically me, had a tough time many years ago, and I appreciate you bringing it back to the table for us to refresh our memories on this. So thank you so much.
Yeah, my pleasure.
And that's it. Have a nice afternoon, everybody. Talk later.